All right. So when, excuse me. So when we left off last time, we were on page 8 of the MAR contract, and we were talking about the limited warranty. So let's see here. So the limited warranty says that if a warranty plan is being offered with the purchase of the property, it may be a limited warranty, and such warranty plans do not cover structural defects and may not cover pre-existing defects. And a buyer should request that the real estate agent provide the buyer with a brochure that describes the plan to determine the extent of the coverage provided by the warranty. So what this paragraph is talking about is it is really just talking about those home warranties that we like to give to our buyers. So that's what it's talking about, because those home warranties, they have different flavors to them. They cover different things. They tend not to cover the structure. Sometimes they cover the roof, sometimes they don't cover the roof. They different appliances, what have you, different co-pays, like maybe a visit is $50 or $100, whatever the case may be. So paragraph 40 is really just talking about those home warranties that a seller may be purchasing for a buyer, or that the buyer is purchasing for themselves, or perhaps you as the agent are purchasing just as a gift for your buyer because you think it's a good idea, or to provide something of value. So paragraph 41 talks about the property insurance brochure. This is an informational brochure published by Maryland Realtors. And it talks about, excuse me, property insurance and what coverages are available for property. The fact of the matter here is that if your purchaser is getting a loan, and this is really talking about hazard insurance, slip and fall, or maybe not so much slip and fall, but if there were some accident to happen to the house, right? Like it burns down. How is it going to get rebuilt? What is the insurance for that? That's what paragraph 41 is talking about. And typically, if there's a lender involved in the transaction, which in most transactions there is a lender, the lender is going to require some form of hazard insurance. So, but the good news is there is a informational brochure that the Maryland Realtors have put together for you, and you can share that with your client. So 42 talks about flood insurance. So this is actually very interesting. So if any of you have sat through settlement with me, I often may say, congratulations, your property is not in a flood zone. However, if at some point in the future the flood maps change, your servicer may require you to purchase flood insurance based on some future existing condition. Well, that's what paragraph 42 is really talking about, because we've had some issues with floods in Maryland. The most common one that I can think of has to do up in Ellicott City, where Ellicott City got flooded a few times, and it originally was not on the flood maps, but obviously it is now. And so this is explaining that there are areas where flood insurance may be required. And so this is a bit of a disclosure. So, and it may not be in an obvious place, like we just worked on a sale out in Calvert County on the bay, and the house had its own private beach and it was lovely. So clearly that one probably is in a floodplain. Although I did a house, maybe it was last year, down on Cobb Island, and I was shocked to find out that was not on a floodplain, even though it was on Cobb Island. And so one of the things you want to advise with your clients, when you're out looking at these things, is you're going to want to know if you're in a flood zone or not. Obviously, if you have a lender, the lender is going to be able to figure this out. But you're going to want to do your homework, because you may need flood insurance. Even in a condominium, you may want it. If you're buying in Ocean City and it's, beachfront condo, you may need wind and flood insurance, because even if you're on the 8th floor, it is still possible that flood insurance may be required. So it could even be in some unlikely places. So what paragraph 42A and B is really getting at is they're talking about, hey, take a look at the flood maps, don't ignore us. And so they've put in the ins and outs of the flood insurance program. So if you are in an area where floods are a problem, they've put in a, let's see, I'll just sort of highlight it here. They've given us, there we go. They've given us these two websites here, FEMA.gov/National Flood Insurance Program. And then there's also this floodmaps.net. And so this is, oh, sorry, I guess I clicked into the place. The link works. So the point is, you can totally be the hero for your client by saying, oh, hey, this looks like we're in a floodplain, or whatever, the case is from the listing, if it's disclosed and you want to know more. Or maybe you're already talking to a client and they've already said to you, hey, just so you know, I don't want to look at any houses in a flood zone. Say, great, let's pull up the Maryland flood map and decide where we're not going to look. Okay. So you can do those things. So that's what this is all about. Paragraph 43 talks about the guarantee fund. Again, this is another notice to the buyer that they are protected by the Real Estate Guarantee Fund for the Maryland Real Estate Commission for losses not exceeding $50,000 for any claim. So that's really just putting them on notice that the guarantee fund exists. And we all know it exists because when we got our licenses, we had to pay into it. And if you get fines, you'll have to pay into it. So paragraph 44 is the single family residential real property disclosure. So this is about the disclaimer statement. So I'm sure that you've talked about that before, but allow me to discuss it. Although I'm not going to go into that particular form, I actually think it's probably the worst form that's ever been written. Well, there's a few on that list, but that's top 10, because that is the form where you can either disclose or disclaim, but I would advise you not to do both, because I would think it's very hard to disclose and disclaim at the same time. However, that is the form where some lenders have actually taken to putting an entire disclosure regarding this particular form, where the document is headed, you have the right to rescind your contract. And I've had to tell people, I said, no, you don't have the right in closing, like, we're here. But what's really going on here is they're putting you on notice that you have the right to receive this disclosure and disclaimer statement. Okay. And that should be, as the seller, you want to make sure that that's part of your disclosure package that you're uploading into Bright, so that other agents can access it for potential offers. Because if a buyer does not get that form, okay, they have, I forget exactly what it is, 4 or 5 days to review that disclosure disclaimer statement and decide to cancel the contract based on what they see in that form. And so, that lender admonishment about, you have the right to rescind your contract. I mean, they're kind of right if that form wasn't provided at the appropriate time. So you want to make sure, as the listing agent, to protect your seller, that you have provided that form with your disclosures, because you want to make sure that the buyer has it and it's been acknowledged, and just get that done and out of the way. All right. Number 45, Maryland non-resident seller. Oh, this is one of my favorites. So, Maryland non-resident seller. So if the property is not the seller's principal residence, excuse me, and the seller is a non-resident individual of Maryland, or is a non-resident entity which is not formed under the laws of the state of Maryland or qualified to do business in Maryland, a withholding tax from the proceeds of the sale may be withheld at the time of settlement, except as otherwise provided by Maryland law. So some of you have gotten calls from me, or one of our processors at least, saying, hey, the seller provided a driver's license from, Florida, Texas, wherever. Looks like they're a non-resident. So we're going to have to start with, so we have to start our inquiry into non-resident withholding. So as a listing agent, I'm going to tell you, it's going to save a lot of time and effort if you understand this. Okay. So if you are dealing with someone that is not a resident of Maryland, it will help your friends at the title company, no matter what title company you use, but it'll certainly help me if you use Realty Title, to put them on notice, like, hey, you're a non-resident, but there's ways around this. But, and one of the most common non-residents that we get are members of the military. And members of the military are very different than most people, because members of the military, even if they were living in Maryland, they can choose their state, what's called their state of domicile. And so you get a lot of military folks that maybe have their domicile in Florida or Washington State or New Hampshire or Tennessee. Basically, I see it with a lot of states where there's no state income tax. That happens quite a bit, but then they come to the DC area because their station may be up at Fort Meade. So we see a lot in Anne Arundel County, like in Odenton area from time to time. And then they're ready to sell their house. And suddenly I take a look at things and say, aha, non-resident withholding. But here's the deal. Depending on when we catch it in the process, and this is why listing agents, I'm looking at you. If you can, at the beginning of the process, like with contract submission, if you are on it, you can help the title company be on it too. Instead of us, waiting through and waiting for the seller information sheets and all of this and upload of driver's licenses and all that, so we can figure out our inquiry. We can actually, there are certain exemptions that apply. If you are working with an investor, there is an exemption for a 1031 exchange. There are exemptions for military members, but here's the catch. As the title company, I can't just give it to you. You have to apply to the state. There is a form that I can give you along with a proposed settlement statement that can be supplied to the comptroller, and you can even email it to them. And they will issue either a partial exemption, an exemption, or they will tax the transaction. But all is not lost. Let's say we just don't catch it and we need to go to settlement. I'm going to tell you as the title company that yes, I will have to withhold. Withholding is 8% for an individual, or like an individual's trust, like a revocable living trust kind of thing. It is 8.5% for an LLC. Okay. So we can go ahead, we do the withholding. I have to do it because I have to present that withholding check to the recorder in order to get the deed on record. But all is not lost. There isn't yet another form I could give you where within 60 days of the transaction, I believe, you can file that form with your seller can file the form with the comptroller of Maryland, and the comptroller will go ahead and tax the transaction. And if there is a refund due from the withholding, the comptroller will take care of it. Okay. So, and this type of withholding that we're talking about is separate and apart from, having to file a tax return with the state of Maryland. Okay. You can do this separately without having to file a whole tax return with Maryland, the way this program is set up. The other thing I will tell you is, the other one I get sometimes is, well, I have a client that moved out of state like 2 months ago. So, they went and got a new driver's license and they're not a Maryland resident anymore, but they were. Well, in that case, there is an exception. If this was the primary principal residence for that particular client for 2 of the last 5 years, and they just happened to move, say 2 months ago, no problem. We just have to know, so that way we can provide the correct forms. We don't have to withhold in that case. So, so a lot of this just has to do with getting the right information to us, so that way we can ensure that the appropriate steps are being made, so that If there are taxes involved, we get everybody on board with it and what have you. So I see some people doing some stuff in the chat. So let's see. So Julia Maynor was asking about property in a flood zone. As your listing agent, do you still need that form? Also for probate and estate can be exempt, right? So what I'm going to tell you is with the disclosure disclaimer form, because I think, Julia, that's what your question was alluding to. A personal representative of an estate, as a personal representative of the state, I would just tell you, you can just disclaim, because you don't really know what the condition of the property is. And so that's fine. So as far as being in a flood zone, this is the whole flood insurance issue. That's really more, putting buyers on notice that these things exist. So it's not so much a disclosure issue. As a seller, if you happen to know that the property is in a flood zone, that's very, very helpful information to provide to a buyer. So it puts them on notice. But I actually don't know of an affirmative requirement to do so because we have these maps. So I would say that the buyer, if the buyer is that interested in understanding, the flood zone and all of that, it's incumbent on the buyer to look at the available information regarding flood zones to make their decisions. So that's what I would say about that. Okay, so let's see. And so let's see, we talked about non-resident seller. So just to sort of wrap that up, it is something that we come across quite a bit. There are certain exemptions that can be applied for with the state. Title companies cannot just grant the exemptions. They have to be applied for, typically within 21 days of settlement. So if you know that this is an issue, bring it up to the title company front and center. So that way we know it's something that has to be dealt with, because there is a timing issue. So otherwise, we have to do what we have to do. And oftentimes it becomes a surprise to the seller, but guess what? You as the agent, as the listing agent, you can save the day and you can prepare your seller and say, oh, you don't live in town. This is the situation. And these are some things that we can do. We can talk to the attorney at the title company. They'll tell us what to do. But that's just what needs to happen. Okay. Let's see. I see there's something in the chat. So interesting question. Julia's asking about non-resident. Doesn't apply to estates, correct? So this is very interesting. So estates can come in two flavors. Our underwriting requires that if you have an estate that that was open, say, I actually have this right now. I have an estate that was open in DC, but we're trying to sell property in Maryland. Although I've had it with West Virginia and North Carolina. And we require that the estate open, that the estate do a foreign filing in the county in which the property is located. And so that basically naturalizes the estate. So that way it gives power to the power of attorney in the in the state. So because this ends up being because because it's sort of like an entity, but you've now registered with the state. I actually believe, although I would have to double check with our underwriters in a fact specific situation, I would double check with our underwriters as to whether or not withholding would be necessary. But I actually don't think it is, because I'm trying to think back to the estates that we've done. And I don't think we've had to do withholding because they've registered as a foreign entity. And once you've registered as a foreign entity, you can be exempt from the withholding. So, so, uh, but some of it may have to do with the specific facts of a particular transaction. So that's where I will leave that. Okay. So paragraph 46, the Internal Revenue Service filing. Buyer and seller each agree to cooperate with the settlement officer by providing all necessary information so a report can be filed with the IRS as required by section 6045 of the IRS code to the extent permitted by law. Any fees for such filing will be incurred by the seller. So I have to admit, this one is taking me a little bit by surprise. So I am going to have to make a note here. Let's see if I have a pen to pull up what section 6045 is, because I don't know if that's FERPTA or if it's something else. So I will send out a little email to those of you who are on here. I'll ask Lindsay, she'll be able to tell me, because we have FERPTA here that's in a different paragraph. So I have to look into what section 6045 is, and get back to you as to what that actually is all about, because that is a new one on me. So look at that. Look at me being totally unprepared for you, but I will get the answers to figure all that out. But I don't think it's something we run across all that much, but it's clearly something someone was concerned about. Okay. So, whoops, come back. Because we still have to finish talking about our notices concerning the Chesapeake and the Atlantic coastal Bay areas and critical areas. So if you have clients that are buying beach houses, okay, whether you're out on the bay or you're out in Ocean City or, you know, wherever you happen to be, okay, this particular paragraph is required to be in every single contract in Maryland, okay? So even though Montgomery County is not mentioned here, this paragraph is required even in Montgomery County and Prince George's County for that matter. Okay. So, but this is talking about the critical area, and it's talking about additional zoning, land use, resource protection regulations that apply in the area. And it talks about that it generally consists of all land and water within 1,000 feet beyond the landward boundaries of the state and or private wetlands, the Chesapeake Bay and the Atlantic coastal bays and their tidal tributaries. These are the critical areas. Basically, what I'm going to tell you is, if you are working with people that are buying houses out, you know, on the bay, that maybe have private beaches or anywhere near water, you're going to want to point this out, that, you know, they could be in a critical area, and you know, if they want to make modifications to the house later, or even if you want to, maybe you have to repair the riprap. Anybody know what riprap is? So riprap is like your seawall. So maybe you have to repair your seawall. Okay. You can't just, you know, hire a contractor, go in and do it. Like, you'll have to probably permit the job out, and it'd be very, very expensive. So you just want to make sure that, you know, there's nothing wrong with purchasing these homes, but you just need to make sure that your buyers know what they are getting into. Okay. So paragraph 48, we're going to talk about wetlands. So the buyer is advised that if property being purchased contains waters of the United States, or property that contains waters regulated by the state, including but not limited to wetlands, approval from the U.S. Army Corps of Engineers, excuse me, and or the Department of the Environment is necessary before starting any work. Okay. And this talks about the flood tidal plain, and more information as to whether the property includes waters of the U.S. You can contact the Baltimore District of the Army Corps of Engineers or the Maryland Department of Environment. You can also engage the services of a qualified specialist to inspect the property. You can include in your written offer a clause making your purchase of the property contingent upon a satisfactory wetlands inspection. So there may be occasions that you want to do this, okay? Maybe there is a vacant piece of land that abuts some water that you want to build on. Well, maybe you want to make sure you can actually build on it. Because I will tell you, typically the state is the one that owns all of the water. So maybe if you were up at Deep Creek Lake in Garrett County, the state owns the water in the lake. The property owners own the property that abut the water. And so there is an interplay between the state and private landowners. Same thing with the Chesapeake Bay. So you may want to, it may make sense for you to have some due diligence clause as recommended here in paragraph 48, depending on the terms of your deal. So paragraph 49 is the Forest Conservation Act notice, okay? So if the property is a tract of land 40,000 square feet or more in size, the buyer is notified that unless exempted by applicable law, as a prerequisite to subdivision or grading, the buyer will be required to comply with the provisions of the Forest Conservation Act. Okay, so basically I would say that, and unless otherwise expressly set forth in the addendum to this contract, the seller represents and warrants that the property is not currently subject to a forest conservation plan. So I would say that if you are selling land that you think is going to be developed, as the seller, maybe you should take a look and make sure that there's no Conservation Act problems, okay? Certainly if you're involved in a very large land transaction. Paragraph 50 talks about conservation easements. So if the property is encumbered by a conservation easement, the contract must contain a notice concerning the easement, which is contained in the attached addendum. The paragraph does not apply to the sale of property in a foreclosure. So what that means is even if you're representing an estate, you need to know if the property has a conservation easement. So maybe you got like a 5-acre plot of land and maybe an acre of it has a conservation easement. So, or maybe you're selling a plot of land for development, maybe some of it has a conservation easement. So as the listing agent, you're going to know these things because we're going to find it in the title search. And we certainly, it certainly could be something that, depending on what the use of the land is going to be, could end up being a problem. Okay. Paragraph 41, FIRPTA. Okay. This is the foreign investment taxes. So here's the situation, folks. As the settlement attorney, I always end up as the bad guy on this, and I don't want to be the bad guy. And for listing agents, you can help us out. FIRPTA applies to people that are not, FIRPTA applies to people that are considered non-US people for purposes of tax jurisdiction. So what does that mean? Well, in order to be a non-foreign person for purposes of US tax jurisdiction, that means you either have a green card, which means you're a permanent resident alien, okay, or you're a US citizen. There is also a third option, okay? Here's your third option. There is something called the substantial presence test. And so if you have a client that is here on a work permit, they may be able, and they have a social security number and they're paying taxes, et cetera, and so on. They may qualify for an exemption under FIRPTA using the substantial presence test, okay? But here's the thing. As the settlement officer, I don't engage in figuring out the substantial presence test. It's actually very complicated because some visas qualify, some visas don't qualify. And there's a whole calculation. So you might be wondering to yourself, well, how do we figure this out? Well, an accountant, we can rely on an accountant certification that a client meets the substantial presence test. And if a seller meets the substantial presence test based on an accountant certification, then we don't have to withhold FERPTA. It's really that simple. But here's the other little thing about FERPTA that is so difficult to, to deal with. So although FERPTA arises because the seller is a foreign individual, as I've already explained, for purposes of tax jurisdiction, it is the buyer's responsibility to pay. And so if we get the FERPTA calculations wrong, you certainly don't want the IRS knocking on the buyer's door saying, hi, where's our $60,000? And so again, listing agents, you can certainly help us out by understanding, if you have questions about FERPTA, certainly I can help you out and direct you if you need an accountant and things like that. But, if we think FERPTA is going to be an issue, and I will tell you, like when I look at driver's licenses, there are certain things that I look at when I review a file that I will start saying, this looks like FERPTA could apply, and we may start asking questions. But if we can find out about these issues early in the transaction, they don't have to be, these issues can turn out to be non-issues, because at the beginning we have time to deal with it instead of realizing it at the last minute and then people are upset. So the story with FERPTA is this: there are several different withholding rates, and some are exempt based on the purchase price, because you see here it talks about $300,000. If a property is $300,000, if the purchase price is $300,000 or less, and the buyer is planning to use the property as their principal residence for the following 2 years, then yes, there is an exemption for FERPTA. Like I said, there are some other exemptions as well that we've just talked about. And FERPTA really is something that we could have an entire class on, but here's what I want you to know about, okay? FERPTA is out there. It's a thing. Realty Title Services, we've taken some classes ourselves with our underwriters, and, we've become more attuned to it. And we've become more attuned to identifying it. And so it shouldn't be it's an issue, but it's an issue that can be overcome. But the fact of the matter is, the withholding for FERPTA, depending on the sales price, is anywhere from 10 to 15% of the gross proceeds. So if you have a contract for $600,000, the withholding is $60,000. And because technically the government doesn't have jurisdiction over that foreign person, that's why the buyer ends up on the hook if tax ultimately is due and it all gets missed. Okay, so we do try to be very careful because we want to protect our buyers, to make sure that we are doing everything that we can do to ensure that they can enjoy their new home. Okay. So that's FERPTA. Paragraph 52 talks about criminal activity and sexual offenders. So here's the deal. All right. Buyer has, here's the deal as agents. Okay. Y'all are going to get into trouble with this. So if your client says to you, is this a safe area? Are there any sexual predators around here? The only thing that you should do, because there are public safety websites around, is, first of all, when you're having your initial consultations, if this is something that people are concerned about, just be like, oh, the state website is here, but that's it. Okay, that's where your place begins and ends. Okay, whether acting as the agent for the seller or buyer, you have no duty or any duty or responsibility to ascertain criminal activity or the presence of a registered sexual offender in the vicinity of the property. This is solely within the sphere of your clients, okay? And part of the reason why you want to be careful here is because you also don't want to be accused of steering or any of the other types of fair housing violations that may come along with this. So if these are things that your clients are talking about, I would tell you that the only thing that you should really be doing is pointing them to public information sources so that they can make their own choices. Okay. But, don't be like, oh, yeah, that's a high crime area. You got to stay out of there. Like, don't do it, because then you start running into other problems. Okay. But what you can do is, if you're, doing a property in Prince George's County and people are interested in crime statistics for a particular place, just be like, well, Prince County, Sheriff's Office, this is the website. Whatever you can find there is whatever's there. Okay. That's okay to do. But that way it's just here's where the public information is if you need help finding it. But outside of that, that's it. You're not there to make judgments or steer your clients one way or the other. Paragraph 53 talks about military installations. Basically, this is just a disclosure to the buyer that a property may be located near a military installation that conducts flight operations or high noise levels. Okay, fine. Paragraph 54 is a notice to the parties, which is this is really talking about water quality on the property due to public or private water systems, the location of sewage disposals, etc. So this is septic systems and so on and so forth. Okay. So so what this is saying is that the agents, nobody's making any representations about septic systems, zoning, anything to do with the property. So if your clients are concerned about the condition of the property, whether it's septic systems, all that kind of stuff, tell them to get an inspection. You make no representations. Okay. And brokers cannot advise, brokers and agents, see, look at B right here, no advising. Okay. So when your client says, well, can you just tell me, you say, I'm sorry, broker, sorry, that's highlighting the wrong thing here. No advising. Brokers and agents are not advising parties on certain issues, including and without limitation, soil conditions, flood hazard areas, possible restrictions of use of properties, leases. And the reason why you can't advise on some of this stuff is, quite frankly, you're not a lawyer. That's why you can't talk about restrictive covenants and leases and environmental laws or easements. Okay, so you're not a lawyer. Although if you're an actor or something, you want to play one on TV, go right ahead. But you're not a lawyer. In addition, I don't know about you, but I'm not a scientist, so I don't know anything about asbestos or lead-based paint or anything like that. So don't advise, you'll get yourself into trouble. And this is even telling your clients, guess what? We're making no representations and we are not advising. And then C is compensation. And guess what? Buyer and seller assume full responsibility for selecting and compensating their own vendors. So even though you as the agent, you may have your list of vendors and you may tell your buyer or seller, well, you can find someone else if you want, or if you need some help finding someone, no problem. Here's some people I've worked with in the past, what have you. All right. Paragraph 55. Okay. Oh, sorry. There is one more thing I want to talk about, which was the Foreclosure of Homeowners and Prevention Act, which was part D of that paragraph 54. Let's see if I can pull that here. Here we go. States that if the mortgage on the property is at least 60 days in default on the date of contract acceptance, the seller has the right to rescind the contract within 5 days after the date of acceptance. Okay. So this is talking about folks that are in trouble. Okay. So just make sure that you understand that if you're dealing with someone that is in default and they say, oh, we need to rescind, pursuant to this section, there you go. you've had that notice. Okay, so I'm just going to roll right through here to paragraph 61, and then I see there's a question in the chat. So here we go. Property tax notice, 60-day appeal. Any real property transferred after January 1st and before the beginning of the next taxable year, the new owner can appeal the valuation classification on or before 60 days after the date of transfer. So that's actually very, very helpful because perhaps maybe the way the property was sold, maybe the assessment is off or something. That's a way to deal with it. 56 is non-assignability. If you're going to assign the contract, it must be done with the written consent of buyer and seller. Okay. And the original parties to the contract will remain obligated with that assignment. Paragraph 57 is just explaining that the contract headings are for convenience, but don't define or limit the rights. Chapter 58. So we talked about time of the essence about 3 weeks ago, probably, because everything in a real estate contract is based on time. But if you ever wanted to know how you're going to calculate time on your contract, paragraph 58 is exactly where we're going to do that. Okay. So the term days means consecutive calendar days. That includes Saturday and Sunday. So guess what? Just because the title company was closed on a Monday holiday does not mean that whatever is going on in your contract needs to be taken care of. Okay. The clock for a contract does not stop. Now, occasionally, because of these things, when you're writing a contract, you may want to take note of when, the Monday federal holidays are, etc. Or when a Sunday is, because occasionally people say, oh, we'll just do the end of the month. But guess what? If the end of the month is on a Sunday, then you're talking about the Friday before. Okay. So just, when you're writing your contract, maybe it's just handy to have a little calendar. But this also explains that, when you're doing home inspections or you need to provide, loan commitments, etc., computation of days is where all of that is going to be. Paragraph 59 just explains that this contract and any addenda thereto are the final agreement. There's no oral representations, okay? Everything is in writing. And that's very important because if you remember from your principles and practices class, you probably talked about the statute of frauds, right? In Maryland, a real estate contract must be in writing. And we don't want to have any separate side agreements. And because if there are, and we don't know about it, and there's lenders involved, that can lead to a fraud on the lender. Okay. And fraud on the lender comes with lovely silver bracelets and orange jumpsuits and possibly a membership to Club Fed. So we want to make sure that we don't have any oral representations. Everything needs to be written down. And that includes, even if you're having emails back and forth about whatever, issue that's coming up, just because you're negotiating a particular issue back and forth on email, make sure that you do take the time to reduce the entire item into an addendum that is ultimately signed by everyone, so that everyone can be on the same page. Paragraph 60 talks about conducting the transaction electronically and the use of electronic signatures. Thank goodness we have that, or all of you using DocuSign and Dotloop and all that stuff wouldn't be able to do it. And then electronic delivery is also very important because we want to be able to contact people via fax or email or digital image. And we're basically saying that digital images and faxed images are just as good as the original. And if that weren't there, I don't know how we would conduct business in the 21st century. And so finally, after 3 weeks and 48 minutes, we've gotten to the end of the Maryland contract. And I said we would talk about the GCAR contract, so I will. But let's see, we have a question here about, let's see, if a buyer says they don't want a home in a particular area because of their research, we should continue to honor, right, for which we didn't suggest. So the issue here is you need you're on the right track, Julia. So the issue here is, you know, you need your buyers to drive the search. If they say, I don't want to look here because I didn't like the research on this particular area, that's okay because that came from them. Okay. If you say, gee, I don't think you're going to like this particular area because of XYZ reason, that's a problem because you can start getting into fair housing problems. But if your buyer's done their own research and they say to you, no, 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 I only want to look in, I only want to look in Durwood because that's, everything that I want. Like, that's fine. That's up to them. Now, you can maybe suggest, well, after you've gone on some showings and say, well, listen, Durwood's kind of tough. It's kind of expensive. You're still looking for, X, Y, Z. Would you care to expand your search, and talk about different ways to expand your search and, there's ways that you can suggest things and have it not be steering, but you want to make sure that, your buyer is basically in the driver's seat because your buyer is coming to you because you have knowledge of the market. But, you can say, well, you're looking for, 5-bedroom, 2-car garage, with a gas stove, and, you want to be within, I don't know, say 30 minutes of 1600 Pennsylvania Avenue. Well, we can draw a big old circle and say, these are the houses. That's okay. And then from there, you can say, well, I don't know, maybe I want to be in Prince George's County. Maybe I want to be in Montgomery County. Maybe I want to be in Upper Northwest. Maybe I want to be in Southeast. I don't know. There's a lot of ways to start, slicing that pie. But I would just tell you to sort of try to keep the search as buyer focused and buyer driven as possible. And you don't want to be steering, okay, because that's illegal. But certainly if a buyer says, no, 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 I don't like this area. So you just say, fine, you don't like the area. Let's move on. So that's fine. Okay. So let's talk about GCAR. So GCAR is very different. Well, I mean, it's not that different, but GCAR is more in sync with Montgomery County and DC. So the Maryland contract that we've just been through, okay, is very much for Maryland. And most of the agents that we see are using the Maryland contract, even in Montgomery County. Now, if you use the Maryland Realtors contract that we've just gone through these last 3 weeks in Montgomery County, you need to make sure that you're using the GCAR jurisdictional addendum for the MAR contract, okay? Because in Montgomery County, there are a lot of little ordinances and things, like there's a radon ordinance in Montgomery County that you need to worry about. And GCAR is also what's used in DC. So if you are doing DC, you need to be using the GCAR contract, okay? So the GCAR contract on its face is a little bit different. The addenda are different. The one thing I like about the GCAR contract in comparison to the MAR contract has to do with settlement fees. In the MAR contract, you're obligating your buyer to pay all of the settlement fees. The GCAR contract obligates the parties to pay their own fees. So that's always much, much better in my opinion. So, but this front page just really explains, it's somewhat similar to the MAR contract in that it just has the who, what, why, where of the who, what, why, where of the contract, buyers, sellers, etc. It also asks you to identify who the brokers are at the beginning, okay, with the listing agent and the selling company, okay. And again, just as a reminder, we talked about this at the beginning of our journey with the Maryland Realtors contract, but it is definitely worth talking about again. Know your parties. Who is your client, okay? If you are representing an estate, make sure you've seen the letters of administration to know that you're dealing with the right person who can sign that contract, okay? Make sure if you are dealing with an investor and there's an LLC, make sure you've seen the operating agreement. Make sure that you know that the person you're dealing with is allowed to sign, is the authorized person for that particular deal. Okay. So know who your parties are. Again, so paragraph 2 here talks about the jurisdictional addendum. They're only talking about for DC or Montgomery County. But if you are using the Maryland Realtors contract, again, I would just tell you there's also a Montgomery County jurisdictional addendum that goes with the Maryland Realtors contract. Make sure that you use that, because I find a lot of people are not. Paragraph 3 talks about the particulars of the transaction in terms of finance. This is laid out a little bit differently. For whatever reason, the folks at GCAR decided they liked percentages better than they liked using actual numbers. When they made this particular change, I was not a fan. I'm still not a fan, but this is probably one of the shortcomings. There's no perfect contract, but here we are. So just remember, you're putting in percentages to equal your total sales price. And then if there's a loan going to be involved, this talks about the loan on the first page. Let's see. So then we're going to move on to page 2. And page 2 is nice because now we're talking about the deposit. So, and this talks about when funds are going to be due, who's holding it, all of this fun stuff. And the deposit is different from settlement. So again, you're going to want to fill in all of these blanks. This is all very, very similar to what you saw with the Maryland Realtors contract. Oh, whoops. Boy, that really jumped, didn't it? I don't know why this thing does that. Whoa. Let's try to get back there. So there we go. Page 2. I think I finally got it. So is it there? There we go. All right. Almost. So this is talking about some different contingencies. We've got access to the property for home inspections. This talks about the home warranty in a different way. This talks about property maintenance and condition. Okay. So, and some of the ideas that are here in the GCAR contract are very similar to what you're going to find in the Maryland Realtors contract, but it's stated a little bit different. And one of the things that this contract does is it evens the playing field a little bit in terms of responsibility, I find. But it is 657. So maybe we'll have to have around 4 next month, and we'll talk a little bit more in depth about the GCAR contract. But one thing I want to just sort of talk about for, the few minutes that we have left is, I've only talked about the base contract really for Maryland Realtors. There are a ton of addenda. You need to make sure that you are using the correct addenda, okay? Because there's the as-is addenda, there's the financing addenda, there's, addenda that sometimes you all need to write to address a particular issue in your transaction. And then, of course, there's also the inclusions and exclusions, and we talked about solar panels before. And so I would just say that, you want to make sure that, you are including all of the appropriate addenda to your contract. So what I had intended to do is to sort of just go over the base contract here first, which I am in the process of doing. And if these 3 sessions really that ended up being on the Maryland Realtors contract have been helpful, perhaps we'll just keep going with our monthly contract, and we'll start in on GCAR. And once we finish on GCAR, maybe we'll attack some of the addenda and talk about some of the differences. Does anyone have any questions? Oops, let's see. Gallery view. So I'm going to stop the share right here. But does anyone have any questions? No? All right, then I'm going to thank you all for taking an hour out of your time to join me tonight. I do appreciate it. And although this was scheduled to be our last of contracts, I'll talk with Alfredo about what we're going to do for the next quarter, and we'll see how it goes from there.
Thank you very much. It was very
Thank you
informative.
very much. Thank you.
Thank you. All right. Well, have a good evening, everyone.
Thank you. You have a good evening too. Bye-bye.
Bye.